Hello, everyone. I'm Alonzo Martinez, Associate General Counsel at HireRight, and this is Navigating Compliance, our 2023 year in review. While I'm a lawyer, today's webinar is not intended as legal or compliance advice. My intentions are to give you information that you'll take as talking points to raise with your teams and your legal counsel. Before we begin, I want to cover a few housekeeping items. As always, during this webinar, please take the conversation to Twitter, or X as we're calling it, using the hashtag HireRightWebinar. In order to receive HRCI or SHRM credit, you must attend the full live session of this webinar. Credit information will be emailed a few days after the webinar. We are not providing copies of today's slides. However, we will send you an email with a link to a recording of this webinar session. If you are experiencing any audio or video issues, please refresh the browser window by clicking F5 on your keyboard, or send us a message using the Q&A icon at the bottom of the screen. Carrie and Doreen are producing today's webinar and will be monitoring the feed for any technical issues. After the presentation, we would appreciate getting your feedback. Please take our brief survey and let us know if this session was helpful. My focus is to create sessions that are meaningful, so we welcome ideas for future topics. So please take 60 seconds out of your day and let us know what you think. And again, please press F5 on your keyboard to refresh this presentation anytime you experience any audio or video problems. 2023 was different. Throughout the year, I've been characterizing the legislation introduced this session as bills that do more with less. As I mentioned that over the last few quarters, it's really held true as we wrap the year. And as I was preparing the materials that we're covering today, I looked back at legislation that was passed in 2021 and in 2022. And to just give you some figures, in 2021, we covered 6 ban-the-box changes, 4 in 2022, and today we're going to cover 2 in our 2023 year in review. By contrast, we didn't cover a single clean slate law in 2021. This year, we're going to cover 8. So when I say that the year was different, what I mean is that legislatures have focused on laws that provide broad protections for job seekers at the expense of additional compliance obligations on employers. And here is what we're going to cover today. You can see the rundown on your screen. I'm going to provide an overview of the current state of the law and offer some practical guidance to comply or to prepare to comply with those laws. As always, we have a lot of ground to cover today. I'm going to try and keep a quick pace through these topics, so please do not consider this to be an in-depth discussion on any one topic, but it should provide you with a good foundation upon which you can explore. And I should mention that if you click on the resources icon in this webinar, you'll find a link to an article that I wrote. It's called the 2023 Download, Reviewing Key Legislation Impacting Employers. Links to the text of all of the laws and material that we're going to cover today are included in that article, the 2023 Download. So it's a really great resource for you to bookmark and reference. And as always, I'm always looking for new opportunities to create content that's beneficial for you. So when you fill out the survey at the end of the webinar, let me know what you'd like me to focus on in future webinars. So as always, settle in for the next hour. And remember, if you have any questions during this webinar, use that Q&A icon and I'll try and cover those at the end. We're going to kick things off today, as always, with a broad discussion concerning criminal history reform. And here is a look at clean slate laws across the United States. Clean slate laws expunge or seal certain criminal records from public access once someone remains crime-free for a period of time. And we're seeing a trend towards adopting clean slate laws. It seems that instead of just restricting an employer's ability to ask a candidate about their criminal history, lawmakers are simply sealing or expunging criminal history, so it's not available to employers. The goal of clean slate laws is to remove the stigma associated with criminal history so that individuals who have offended have an easier time getting a job. The impact to you as employers is that if a record has been sealed or expunged from the court's indexes, then it can't be found. So it's not going to be reported to you on a criminal background check. So as a result, you'll probably start seeing less criminal hits in all of these jurisdictions. As you can see on the screen, every state except for Wisconsin offers some form of post-conviction expungement or sealing of qualifying criminal offenses to varying degrees, from the states in red that extend to felony and misdemeanor convictions to those in that orange or terracotta color that apply to limited offenses as specified by the state. Those states that feature a star offer automatic expungement or sealing of qualifying crimes, while those without a star require that an ex-offender petition the court for relief. Wisconsin offers judicial pardons, but criminal records are not sealed or expunged. But that will probably change within the next few legislative seasons. And here is an overview of clean slate laws that were passed or became effective in 2023. I've listed these in chronological order of effective date for you. Connecticut's law became effective at the start of the year and was supposed to provide broad automatic expungement of most nonviolent felonies and misdemeanors. But the state has had some problems identifying and expunging those eligible offenses. So as of now, only cannabis offenses are automatically expunged. So unfortunately, for individuals with criminal history that would be eligible for automatic expungement, their criminal records will continue to be available in a court system, and as a result, will continue to be reported to you as normal. Utah, Washington, D.C., and Arizona all have petition-based processes for expungement. California leads the country in criminal history reform by extending automatic relief to felony-level offenses after only 4 years. That's a really short period of time comparatively. And in California, automatic expungement becomes available for most defendants convicted of most nonviolent felonies. Even those convicted of violent or other serious felony offenses, they can petition a court for expungement. California is by far the most generous clean slate law for ex-offenders. Idaho also permits petition-based sealing of relatively minor, non-violent, non-sexual offenses. New York, in 2023, expanded its clean slate law. The new legislation automatically seals eligible cases, so there's no need to apply for expungement. Misdemeanor offenses are automatically sealed 3 years after the term of the sentence. Eligible felony convictions are sealed 8 years after the duration of the sentence. Class A felonies and convictions requiring registration as a sex offender, those are ineligible for automatic sealing. And Virginia amended its law to provide automatic relief for dismissed cases and some misdemeanors and allow for petition-based sealing for several misdemeanor and felony convictions. They actually pushed back their clean slate law a bit in 2023. We recently published 2 new white papers, Automatic Criminal Record Relief Volumes 1 and 2, that cover clean slate laws applicable to convictions in Volume 1 and non-convictions in Volume 2. Those white papers are available for download at the HireRight Resource Library. You're also going to find a link to those white papers in the resources section of this webinar. So check those out. They're very helpful as it relates to clean slate legislation. As I mentioned at the top of the call, while there has been a lot of movement with sealing and expunging criminal history through clean slate laws, there have been very few developments in the ban the box arena. But I do have a couple of updates which we're going to cover shortly. But first, here is a look at the landscape of ban the box jurisdictions impacting private employers at the state and local levels. In all 39 of the jurisdictions you see on the screen, you can't ask the "have you ever been convicted of a crime" question until some later time in the hiring process. In the 19 jurisdictions you see on the screen in red text, the ban the box measure applies to any form of work for monetary gain. So if you pay somebody to do a job, then they're subject to the ban the box measure. So this would include not only your traditional employees, but also contractors. As you've heard me say in the past, I love saying this, not all ban the box laws are created equal. In all ban the box jurisdictions, you generally can't ask a candidate if they've been convicted of a crime during the initial application or request a criminal background check until after a conditional offer of employment has been extended. Those are those jurisdictions that you see in that gray standard box. But there are also some jurisdictions that require special handling. On the screen, you're going to see those in that aqua column that require that you identify the criminal conduct that may disqualify an individual from hire. And then there's those jurisdictions in the blue column that require that you conduct and provide an individualized assessment that relates a candidate's criminal conduct to their job as part of the pre-adverse action process. And then in Los Angeles and New York City, shown in that wine-colored column on your screen, you also need to provide additional city-provided notices or substantially similar forms as part of the pre-adverse action process. Then, to make things a little more complicated, there are 4 jurisdictions, Louisiana, New York, Atlanta, Georgia, and Gainesville, Florida, that don't specifically ban the box, but do require that you conduct an individualized assessment. And again, an individualized assessment is your analysis of the candidate's criminal history and its potential relationship to the position for which they've applied or under consideration. While you have to perform the analysis, you don't necessarily need to provide it to the candidate in those 4 jurisdictions. The EEOC's 2012 guidance to employers concerning the use of arrest and conviction records is a really good read that can help you understand the individualized assessment process if you're unfamiliar with it. I've linked to it in the resources section of this webinar. It is an incredibly helpful piece of guidance, so please review it if you have any questions about the individualized assessment process. So the bottom line, as you can see, is that you cannot adopt a one-size-fits-all model for compliance. You're going to have to modify your adjudication, pre-adverse, and adverse action practices to align with a particular jurisdiction's law. With that said, just a quick reminder that you can use HireRight's compliance web workbench solution to manage your ban-the-box obligations. The solution, HireRight's compliance workbench, is made available for free. So let us know if you want more information when you fill out the survey at the end of today's webinar. Quick plug, you can find our Ban the Box white paper on the resource library. And if you're a HireRight client, you can also find our sample pre-adverse and adverse action templates for your reference in Compliance Central within Screening Manager. Again, we've linked to that in the resource section of this webinar. And I want to provide you with an update on what happened in 2023. That is Chicago's amended Ban the Box ordinance. So let's focus on what changed. First, the ordinance applies to any employer of any size with an office or facility in Chicago or who is required to hold a business license to operate in Chicago. Realistically, that's probably any business operating in the city of Chicago. Previously, the ordinance only applied to those organizations that employed 15 or more workers. Chicago's ordinance also limits an employer's ability to adversely impact an individual who has criminal history unless that conviction bears a substantial relationship to the position sought, or the employer believes that an individual poses an unreasonable risk to safety. What this means is that you're going to need to conduct an individualized assessment that looks at the length of the time since the conviction, the number of convictions that appear on the conviction record, the nature and severity of the conviction, and its relationship to the safety or security of others, and the facts or circumstances surrounding that conviction. You'll also want to look at the age of the employee at the time of the conviction and any evidence of rehabilitation efforts. There are also changes to the pre-adverse and adverse action processes. As part of the pre-adverse process, you're going to need to include your reasoning as to why the candidate's criminal history may disqualify them for hire. So effectively, the outcome of that individualized assessment. You're also going to need to advise the candidate that they have at least 5 days to submit any evidence of rehabilitation to you. And as part of the adverse action process, the adverse action notice needs to include the reason behind your decision not to hire the candidate. So you're going to want to include that individualized assessment again. You'll also want to include the candidate's right to file a complaint with the Chicago Commission on Human Relations, as well as any mechanism to challenge your decision. How do they get in touch with you to challenge your decision? So this is obviously very different from your standard pre-adverse and adverse action letters. Again, for HireRight customers, you're going to need to manage your compliance obligations, these Chicago-specific pre-adverse and adverse action requirements, either within Compliance Workbench or outside of our platform. Let us know if you need more information on that. Let's talk about what's going on in California. If you are a HireRight customer, you should have received a few updates concerning California's amended Fair Chance Act, which I've summarized for you on the screen. Let's run through some of those updates. First, the definition of an employer has been greatly expanded. The term employer includes not only direct employers, but also entities acting as agents or evaluating an applicant's criminal history on behalf of the employer. So staffing agencies and entities obtaining workers from a pool or availability list, those are added to this definition of employer. So this means that any entity that grades or makes an employment decision based on an individual's criminal history, they are on the hook to comply with the revised Fair Chance Act. The revised regulations add 2 categories of employees in its definition of an applicant. 1, existing employees who have applied for or indicated a specific desire to be considered for a different position with their current employer. And 2, existing employees who are subject to review or consideration for criminal history because of a change in ownership, management, policy, or practice at the firm. So what are the key changes and implications for you as employers? Well, the revised regulation clarifies that with limited exceptions, employers have no legal obligation to check the criminal histories of job applicants or current employees. Only employers required by law to conduct criminal background checks can do so before making a conditional offer of employment. Other employers, they can conduct criminal checks after extending a conditional offer of employment. That hasn't changed. So again, you conduct a background check after a conditional offer of employment. All employers that conduct criminal background checks have to adhere to the legal limitations outlined in the regulations. So let's cover those legal limitations. So let's say a background check reports criminal history on a California applicant. Then step one, an employer needs to conduct an individualized assessment. That hasn't changed, but the scope of the individualized assessment has been expanded. It's far more nuanced. HireRight customers, we've published new criminal history questionnaires and individualized assessment templates for you to reference. Those are available in Screening Manager and in Compliance Central. Okay, so let's say that after that initial assessment, you believe that an applicant's criminal history poses an issue for your organization based on those roles and responsibilities of the job. Then step two, you have to notify the applicant in writing of your preliminary decision to possibly deny the applicant employment based on their criminal history. As part of that notice, the pre-adverse action process, you have to provide a copy of the criminal history conviction report, identify the disqualifying conviction that's the basis for the preliminary decision, as well as information about the applicant's right to respond to the notice before the preliminary decision becomes final, and an explanation of the types of evidence an applicant can submit to challenge the conviction history or evidence of rehabilitation or mitigation, along with the deadline for a response from the applicant. Employers can't require that an applicant provide a specific type of evidence demonstrating their rehabilitation. An applicant can voluntarily provide evidence of rehabilitation or mitigating circumstances, and employers can't refuse to accept any evidence provided by the applicant. They have to carefully evaluate any information provided by the applicant and give applicants a fair chance to demonstrate their qualifications and readiness for a role. Employers also can't disqualify an applicant for failing to provide a specific type of evidence. Again, it's up to the applicant to decide if they want to engage in that dialogue with you. Okay, so let's say you've reviewed the applicant's criminal history and any evidence of rehabilitation that the applicant voluntarily provided, and you still decide to move forward by adversely impacting the applicant's employment. You decide that their criminal history provides too much risk for your organization. Then step three, after waiting at least 5 business days, if you're using email or other electronic means to send the pre-adverse action notice, then as part of the adverse action process, the California Fair Chance regulation requires that an employer identify the candidate's right to file a complaint with the California Civil Rights Department, challenging the employer's decision. So those are the fundamental changes to the pre-adverse and adverse action processes. As you can see, it's very, very nuanced. And again, you're going to need to manage your compliance obligations, these California-specific individualized assessment, pre-adverse and adverse action requirements, either within Compliance Workbench or outside of our platform if you are a HireRight customer. A lot of changes as it relates to California. So here is our recap as we navigate compliance. I always try and bring you some actionable guidance to help you comply with all of these changes. So starting off, as a reminder, if you ask candidates to self-disclose their criminal history, you should periodically review your questions and any state or local instructions or notices that you provide to your candidates to maintain compliance with any clean slate or ban the box laws. It's always your responsibility as employers to ensure that these notices and questions are compliant and relevant for your screening program. Just a general reminder to make sure that you're familiar with and have established processes to comply with the specialized notices and assessments that are required in ban the box jurisdictions. Remember, in California, you're now required to complete an enhanced individualized assessment process, and you can't use your standard pre-adverse and adverse action letters for Chicago or California candidates. You're going to need to ensure that they're tailored specifically to the amended ban the box ordinance's requirements. Again, if you're a HireRight client, you can manage those processes in Compliance Workbench or outside of our platform if you prefer, but you cannot take a one-size-fits-all approach to ban the box compliance. So as we close out this section, I want to remind you to get your questions in using the Q&A icon at the bottom of the screen. All right, let's shift gears and talk about pay equity measures. Remember that pay equity measures look to promote equal pay for equal work and will often include a ban on asking a candidate about their former compensation until some later point in the hiring process. And pay transparency measures require that you share a pay range with candidates and in some case with employees as well. And here's a map I've created that shows you the jurisdictions that prohibit you from asking a job applicant or a candidate about their salary history. There are now 28 cities, counties, or states that have enacted salary history bans. And while you can't ask about former compensation or base future compensation on an individual's compensation history, you can always ask them about their salary or pay expectations. Asking, what do you expect to make in this role? That is permitted 100% of the time. And like I mentioned at the top of the call, while salary history bans were trending for a couple of years, they've largely been replaced by pay transparency laws. That said, we do have two new additions to our list. That's Columbus, Ohio, which joins Cincinnati, and Toledo, also in Ohio, in prohibiting employers from asking applicants about their salary history or relying on salary history for compensation decisions. The law applies to employers with 15 or more employees in Columbus. And in Minnesota, any employer in Minnesota cannot inquire about an applicant's previous compensation or benefits. That includes remote positions. That said, Minnesota's law does not apply if the applicant's salary is a matter of public record or if the applicant voluntarily discloses their salary as part of a salary negotiation. In those cases, the pay history law does not apply. And now here is a map I've created to show you the jurisdictions that require that you either post or provide a salary range for any open positions. Most pay transparency laws note that the range you publish is what you reasonably expect to pay the worker. So you'll likely need to conduct a pay analysis by role to determine the minimum and maximum ranges for those roles and share the pay range within any job posts or advertisements. And here is a table that breaks down pay transparency laws that were passed or became effective in 2023. Starting with California. California is one of the largest jurisdictions to require pay transparency in job postings. It applies to any employer in the state. Timing is a little different for employers in Rhode Island. Pay transparency is required upon request for candidates or before a compensation discussion and at the time of hire or new position for employees. Next is Washington's amended equal pay law, which requires employers with 15 or more employees to disclose the wage scale or salary range and benefits in job postings. Again, benefits are in scope for Washington's law. Both Albany County, New York, and the state of New York require pay transparency. The difference, though, is the geographic scope of those laws. You can see that Albany's law applies to any employer in Albany County, whereas New York State's law applies to positions with any employer with 4 or more employees, except temporary help firms and governmental agencies. More specifically, New York's law applies to jobs physically performed in New York or physically performed outside of New York, but reporting to a supervisor, office, or job site in New York State. So New York's law is a little bit more nuanced here in that there has to be some physical attachment to the state. Remember that there are other jurisdictions within New York State that also have pay transparency laws, so you'll want to be familiar with those. Colorado's pay transparency law is far more technical. I'm going to cover that in the next slide. Let's move on to Hawaii. Hawaii's measure only impacts employers with 50 or more employees and only applies to new hires. So the impact to most employers is really minimal, as a large percentage of employers in Hawaii are far smaller than the reach of the law. On the other hand, in Illinois, employers with 15 or more employees need to disclose the pay scale and a general description of benefits in job postings. There are also pay transparency requirements for internal positions in Illinois, and employers will have to announce any promotional opportunities to current employees no later than 14 calendar days after the employer advertises the job to prospective external employees. So let's now circle back to Colorado. Colorado has led the nation when it comes to pay transparency. It was the first jurisdiction to enact a pay transparency law back in 2021. And in 2023, it has clarified and expanded the scope of the law. So you'll remember that when I told you about the requirement in Illinois to notify employees about promotional opportunities. Well, Colorado expands on this concept to include notification requirements for any job opportunities, including promotional opportunities that your existing workforce may want to consider. So realistically, that's probably most of your job advertisement. And you're going to see those notice requirements on the screen. As part of the pre-hire process, the notification to your existing employees needs to include wage and salary range and a general description of any benefits and any other compensation for that position. The notice should tell your workers the date that the application window for the job opportunity is expected to close, when you're going to stop accepting those applications. And then here's the interesting thing. As part of the post-hire process, within 30 days of selecting a candidate for a job opportunity, you're going to need to notify the colleagues of the person that you selected for the job of the person's name, their former job title, only if they were hired from within the company. If they're external, you can omit this job title requirement. You'll also need to let the colleagues know this person's new job title and information concerning how your employees can express interest in similar opportunities in the future. So that would be a statement like, visit our job board to learn more about similar job opportunities, or contact HR about job opportunities. Something like that needs to be made available to the colleagues of this new worker. There is an exception for employers not physically located in Colorado and with fewer than 15 employees working remotely in Colorado, but all other employers must follow the pre and post-hire notice requirements for all job opportunities that an internal candidate is eligible for. Again, there is a lot going on with Colorado's pay transparency law. It is extremely nuanced. I highly, highly recommend that you take a good look at it. All right, as we wrap our pay equity and transparency discussion, remember to assess your policies and procedures to comply with pay transparency laws and salary history bands. This means conducting a pay analysis and posting pay ranges in many cases, both internally and externally. And if you're still asking candidates to disclose their former compensation, you may want to rethink that practice. Many employers are adopting universal practices to no longer ask about salary and are being transparent about their pay practices. Again, if you operate in Colorado or if your jobs could be performed by remote workers in Colorado, it's worth taking a detailed look at their pay equity law. There is a link to a blog that I wrote that covers Colorado's law in the resources section of this webinar. So I highly recommend that you check that blog out if you do have questions about Colorado's law. And with that, that is our pay equity and transparency discussion. Please continue to use that Q&A icon to submit your questions. We're getting really good audience engagement, so I really appreciate that. We're going to cover your questions at the end of today's webinar. Let's keep it moving into our potpourri category. I'm going to cover general legislation and litigation updates that warrant your attention but don't necessarily fit elsewhere in this presentation. All right, sticking with Colorado, they've passed a law that prohibits you from collecting any information related to age, date of birth, or dates of attendance or graduation from an educational institution on initial employment applications. Again, this is only relevant to initial employment applications. This information can be collected later in the hiring lifecycle, for example, when you request a background check, but you have to remove this information from initial employment applications. For what it's worth, California, Connecticut, Minnesota, and Pennsylvania also have laws restricting age-related information in initial employment applications. And now let's move into litigation. It's time for some audience participation, my favorite part of the webinar. I'm going to walk you through the facts of the case, and then I'm going to ask you to be the judge. In this case, we're talking about disclosure requirements that the Fair Credit Reporting Act, the FCRA, this is, of course, the regulation at the federal level that regulates how an employer gets background checks from vendors like HireRight, consumer reporting agencies. And the FCRA, it imposes certain disclosure requirements on employers. That's what we're going to talk about in this case. So here are the facts. Listen up. The plaintiff applied for employment with a logistics company through its website. The logistics company conducts background checks of its candidates for employment. So they provide the plaintiff with 2 FCRA forms, 1, an FCRA disclosure, and 2, an FCRA authorization form. In her complaint, the plaintiff alleges that the company's disclosure form contains three elements that violate the FCRA. First, the disclosure form includes a checkbox for the plaintiff to acknowledge that her electronic signature is the legally binding equivalent to her handwritten signature, and that she's reviewed and understood this agreement, which is the disclosure. Second, the disclosure form allegedly misstates the law by stating these consumer reports may be obtained by the company at any time after the receipt of your authorization to obtain the reports, and if you are hired by the company throughout your employment with the company, subject to applicable law. Third, the webpage displaying the disclosure form contained external links, such as tabs across the top of the page, links to various social media platforms, and links at the bottom of the page. So those are the facts of the case, and that is the plaintiff's complaint. Give you another second to review those facts and the complaint. Okay, so here is your opportunity to be the judge. Did the company's background check disclosure form violate the FCRA? Was the inclusion of that checkbox, those links, that statement that a background check can be run at any time that the individual is employed, did those things, those items, violate the Fair Credit Reporting Act's disclosure requirements? Yes or no? I'll give you just a few more seconds to get your responses in. All right. Let's see. All right. So here are the responses. We see that the majority of respondents feel like the inclusion of these particular items did violate the FCRA. Well, surprise, surprise. The court actually sided with the employer here. This is a very, very rare win for an employer. The answer is no. The court granted the employer, the company, logistic company's motions to dismiss, finding that the company's background check disclosure forms did not violate the FCRA. Let's talk about each of the complaints raised. First, that checkbox agreement. The plaintiff argued that the checkbox agreement violates the FCRA because it was extraneous. Basically, let me walk you through that. They basically said that the checkbox agreement violated the FCRA's requirement that the document provided to the candidate consist solely of the background check disclosure. The logistics company countered. They argued that the checkbox agreement focused the applicant's attention on the FCRA disclosure. They also asserted that the FCRA expressly allows an employer to seek an applicant's authorization on the disclosure itself. And the court agreed, finding the purpose of the checkbox was to confirm that the applicant understood the disclosure before authorizing the company to obtain a consumer report. So the checkbox was fine in that respect. Concerning the second complaint, the plaintiff argued that the FCRA requires that an employer obtain authorization before each consumer report. The logistics company responded by saying that the statement of law is accurate because the FCRA does not require a new disclosure and authorization for each consumer report. And the court agreed that the statement does not violate the FCRA. The plain language of the statute, the FCRA, authorizes an employer to obtain an employee's written authorization at any time during the employment relationship. Likewise, the Federal Trade Commission, the FTC, published a staff opinion letter concerning that position. So, because the statement of law is accurate and it helps the applicant understand the disclosure process, the court found that the company can include this evergreen disclosure on its disclosure form. I should note, though, that certain states, in particular California, are a little less clear with respect to evergreen consent. So you want to be cautious about evergreen consent statements. But as it relates to this case, the court said it was okay. And the third complaint. The plaintiff argued that the company's disclosure form violated the FCRA because the website contained external links, which were extraneous. The logistics company countered that the links are not extraneous information because they're not information at all. They were navigational elements. And again, the court holds that the external links do not violate the FCRA. So, hat trick for the logistics company, 3 for 3. You might remember that information like liability waivers, state mandated disclosures, and an applicant's right to inspect consumer reports, those items are extraneous because they pull the applicant's attention away from his privacy rights protected by the FCRA. In this case, though, the external links are different. They're navigational. They relate to how to navigate the page, or they send you to a social media platform. They're not extraneous information because just like an employee logo, they're not likely to confuse the applicant. Applicants are accustomed to reading such materials on a website. They don't detract from the FCRA. So there you have it, a rare win for the employer with what I think is really great actionable guidance for you to digest as you assess your disclosures and your screening programs. Moving on, just a quick note while we are on the topic of the FCRA. A revised Fair Credit Reporting Act, or FCRA Summary of Rights, has been issued by the Consumer Financial Protection Bureau, the CFPB. The changes are minimal. They basically updated contact information for a variety of federal agencies. As a reminder, employers need to provide the FCRA Summary of Rights along with a copy of the background report as part of the pre-adverse action process. This is the process that you follow when you might disqualify an individual from hire or affect a worker's employment based in whole or in part on the results of a background check. The CFPB issued those documents last spring. The new FCRA Summary of Rights must be in place by March 20th of 2024. At HireRight, we've engaged in a change management process. But if you manage the pre-adverse and adverse action process outside of our platform, please ensure that you update your processes to include the new document by March 20th of 2024. And that wraps up our potpourri category. As we navigate compliance, remember that you do not ask job applicants for any information that relates to their age on an initial employment application if you are hiring in California, Colorado, Connecticut, Minnesota, or Pennsylvania. You can, of course, adopt a single policy that eliminates age-related inquiries across all hiring locations if you choose to do so. You should review your disclosure and authorization forms for extraneous information. Remember that you're responsible for the content and compliance of the forms that you use. And make sure that the FCRA Summary of Rights that you provide to candidates is the current version of the document that was issued by the CFPB in 2023. Remember that they issued two different FCRA Summary of Rights in 2023, both with the exact same file name, so it is a little confusing. You want to make sure that you use the second and most current copy. Again, if you have any questions about any of these issues, in particular the case that we covered, please use the Q&A icon at the bottom of the screen, and we'll get to your questions at the end of this webinar. All right, so let's move on and talk about cannabis reform. You're going to hear me use the terms cannabis and marijuana and THC interchangeably. Cannabis, marijuana, THC, they're all the same thing for the purposes of our discussion today, so please do not let that confuse you. And here is our medical cannabis map. You see that I've revised the categories in the last few quarters to hopefully make this a lot easier to read. Looking at your screen, you're going to see the states in red where accommodation is likely not required, states in aqua where anti-discrimination measures are in place and where reasonable accommodation of medical marijuana is required, and states in blue where the law is silent on the issue of accommodation. And in Philadelphia, shown in purple or that wine color, they have banned pre-employment marijuana testing. The remaining states in gray haven't passed a medical cannabis law. When I talk about marijuana accommodation, I mean that in certain states, you cannot discriminate against an individual just because they are a lawful user of cannabis. And of course, the need to accommodate not only differs by state, but also by role. For example, there are typically, but not always, exceptions to accommodation for individuals in certain safety-sensitive positions, but there are always exceptions for those in DOT-regulated positions. So important to remember. You might have noticed that new to our map is Kentucky, which passed a medical marijuana law in 2023. Kentucky's law does not require that employers permit or otherwise accommodate its use. So you can test for marijuana and you can adversely impact the employment of anyone who tests positive based on current state law. You can also prohibit a registered user of medical marijuana from performing in safety-sensitive roles and can contractually prohibit vendors from assigning workers to you who use medical marijuana. Kentucky's law became effective at the start of the year. And here is our recreational marijuana map, which I've also revised. For clarity, as you can see on the screen, 23 states and Washington, D.C. have legalized recreational cannabis, also known as adult use legalization. While locations in red have no impact on employers, those jurisdictions shown in aqua, blue, or purple, wine, are different. Those jurisdictions shown in aqua allow for pre-employment testing for cannabis, but the statutes say that an employer cannot impact an individual due to a positive test for THC. And in California and Washington, shown in blue, you will not be able to conduct pre-employment tests for non-psychoactive THC metabolites. Talk more about that in a minute. And in New York State and Minnesota, pre-employment testing for cannabis is prohibited unless an exception applies. Those exceptions are very limited. So please make sure that you've aligned your drug testing panels accordingly. This isn't something that's automatically done for you. It requires your direction since some of your positions may be exempt from the prohibition on testing. Again, let us know if you need help with this when you complete the survey at the end of the webinar. So let's run through some of the upcoming new or amended recreational marijuana laws. Again, I'm going to just focus on the highlights that might drive drug screening program changes for you and keep a quick clip through this. As I just mentioned at the start of the year, California employers are prohibited from discriminating against workers who use marijuana while off-duty and off-premises. Employers are also prohibited from adversely affecting the employment of a worker who tests positive for non-psychoactive cannabis metabolites. Psychoactive metabolites are those that make somebody feel high. So psychoactive metabolites, they make somebody feel high. Non-psychoactive metabolites, they don't indicate impairment. They only tell us that cannabis was recently used. The law doesn't impact an employer's ability to deny marijuana users who are in certain construction roles or in federally regulated jobs, but there is no safety-sensitive exception for California's law. So how do you test for psychoactive metabolites? Oral fluid is a screening option. So you might consider that as you modify your policies and processes to comply with California's law. Let's look at Delaware. Delaware's recreational marijuana law became effective in the second quarter, and while it offers no protections for recreational users, the state also permits the medical use of marijuana and requires that employers reasonably accommodate its use. So if you get drug test results that are positive for marijuana in Delaware, you're going to need to understand if an individual with the positive result is a recreational or medical user of marijuana, and then act accordingly with respect to your adjudication. In Maryland, adults are able to lawfully use recreational marijuana, and as in Delaware, medical marijuana is already legal in the state. However, neither Maryland's medical nor recreational marijuana laws provides any employment protections for users, so there's no real impact to you as employers. In Minnesota, pre-employment testing for cannabis is prohibited unless an exception applies. So please make sure that you've aligned your drug testing panels accordingly. Again, you need to do this for New York as well. Washington, like California, has also banned testing for non-psychoactive cannabis metabolites. So again, you're going to need to reassess marijuana testing in Washington state. And if you find it necessary to continue testing for marijuana, then you may consider oral fluid as a testing option. And as I wrap our recreational marijuana discussion, here is a review of Washington, D.C.'s Cannabis Employment Protections Amendment Act. Employers cannot adversely impact an person's employment based on their use of medical marijuana or the presence of any marijuana metabolites that's recreational or medical in any drug test without additional factors indicating impairment. So again, really broad protections for all users of marijuana. And while you don't need to remove THC from your testing panels, you may choose to do so since you can't adjudicate a positive result unless there are other factors of impairment. I'll quickly note that Washington, D.C. also has a notice requirement. You have to post a notice in your workplace. However, the district has not yet posted a notice, so that notice requirement is not yet enforced. So here is our actionable guidance summary. I'll lead by saying that it's impractical to maintain zero tolerance drug policies. Instead, employers should focus on cannabis use and impairment at work and ensure that policies are amended to reflect that position. It's also really important to adjust your policies and practices so that if a drug test is positive for marijuana, you understand whether the individual is a medical user or a recreational user. In some cases, you might have to accommodate the medical use of marijuana, but not recreational use. And in some jurisdictions like Washington, D.C., you have to accommodate all marijuana use, period. Finally, remember to revise your drug testing panels to exclude marijuana use where required for most jobs, such as in Minnesota. And in California and Washington State, exclude for non-psychoactive marijuana metabolites. You can't use urine or hair tests anymore in those jurisdictions. You're going to need to use oral fluid or simply remove marijuana from your drug testing panels altogether. Adjustments to your drug test panels is not something that your screening provider is going to do for you, because we don't know if a candidate you're testing may work in a position where marijuana testing is permitted, or impacting the employment of someone who tests positive is also permitted. Again, this is your responsibility, so you're going to have to adjust those drug test panels. But you can let us know if you need help adjusting those drug test panels when you can complete the survey at the end of today's webinar. And to reiterate, any jurisdiction that has passed a law legalizing marijuana either for medical or recreational use always exempts DOT-regulated positions, positions serving a federal contract or subject to federal funding, and in many cases, but not always, safety-sensitive positions as defined by that jurisdiction's statute. Again, California has no safety-sensitive exceptions. So that is everything that I have on marijuana legalization. If you are still confused about what is or is not allowed, then now is your time to get in your questions using that Q&A icon at the bottom of the screen. We will get to those in just a few minutes as we wrap this webinar. And now let's quickly cover 3 important updates concerning I-9 and E-Verify. First, there is a new version of Form I-9 that has been published by DHS, the Department of Homeland Security. I've linked to the form in the resources section of this webinar. There are several changes to the form which are outlined on the screen. All employers should have begun using the new version of Form I-9 by November 1st, 2023. I want to focus on that last bullet in red. This is a really big deal. The new form has a checkbox that permits E-Verify customers to indicate that they have remotely virtually inspected a worker's I-9 documents. So how does that work? Well, here is the workflow provided by USCIS on the screen. I've linked to it as well in the resources section of this webinar. If you are not enrolled in E-Verify, then you have to use the standard in-person process to review a person's I-9 documents. But you may be encouraged to enroll in E-Verify because of this particular process, this workflow. As of August 1st, 2023, if you've enrolled in E-Verify and if you are in good standing, you can now use a virtual remote process for I-9 completion. You first have to ask your new employee to review the I-9 list of acceptable documents and send you either a List A document or List B and C documents. That really hasn't changed. They'll need to send you a clear and legible copy of both the front and the back of those documents. You're going to schedule a video call with them and walk them through the 3 steps I've outlined on the right side of the screen. Basically, they're going to show you the same documents that they previously sent you so that you can see that if they're reasonably genuine and that they match that new hire. Then take a look at the 3rd box on the left side of the screen. You're going to mark the checkbox in the additional information field of section 2 to show that the employer used the remote document verification procedure. If you are still using the 2019 version of Form I-9, then obviously you need to move into the 2023 version. So Step 4, you're going to keep clear and legible copies of the employee's documentation within the completed Form I-9. Remember that you have to produce the Form I-9 and the copies of your documents to the USCIS during an I-9 inspection or an enforcement action. Hopefully you won't be in an enforcement action, but if you are, you need to retain and produce those copies. And finally, you're required to open an E-Verify case inquiry by the end of the 3rd business day after the hire. Quick note, employers should not open E-Verify cases when re-verifying Form I-9. That is the process. It's for you on the screen. Again, I've linked to the workflow within the resources section of this webinar. It is a really, really great process to use I-9 in combination with E-Verify, and I highly recommend employers who are not using E-Verify currently to consider it, as it opens up this remote verification process for you. And I'm going to wrap with a quick reminder. All I-9s that were virtually inspected during the COVID-19 pandemic should have been re-verified by August 30th. Remember, you should have either re-verified I-9 documents presented to you during the pandemic, either physically or in person, or by remote virtual means, if you originally created an E-Verify case for that new hire, you had to have re-verified all of those I-9s that were virtually inspected during the pandemic by August 30th. Make sure that you have done that and you've completed your re-verification. I expect that this could be the subject of enforcement actions in 2024. And to recap, you should have transitioned to new Form I-9 by November 1st, 2023. HireRight customers who use our I-9 solution received information about the transition to the new Form I-9 on our platform over the course of the end of last year. Remember to make sure you familiarize yourself and your teams with the new Form I-9 so as to minimize the likelihood of errors in the I-9 process. E-Verify employers can use the virtual remote verification process, and new Form I-9 has a checkbox that lets employers indicate that they've used the virtual remote verification process. And you should have re-verified any List A or B and C documents that you accepted using remote virtual means during the pandemic by August 30th. As a reminder, HireRight offers an I-9 solution with a digital audit trail, supports E-Verify, and offers remote in-person I-9 services. So please let us know if we can help you with any of your I-9 or E-Verify needs. Again, we've linked to several resources in this webinar, so you may want to bookmark those and copy or paste them into an email for your future reference. And here is a quick plug as you get your questions in for our Q&A session. We have several outlets of information for you to consume. So if something piqued your interest, check out our resources library, our blog, or our Forbes article to learn more. And again, that 2023 download article that is available here within the resources section of this webinar, great article with links to all of the laws and measures that we have discussed in today's webinar, and then some actually. All right. So I have time for a few questions now, and all of the questions that are received today will be consolidated and turned into a post that you can find on the HireRight blog in a few weeks. If we don't get to your question today and it's pressing, please let me know when you complete the survey and we will get back to you more quickly. So let me pull things over and take a look. Incredible engagement today. Over 100 questions, and there are a few thousand of you attending today's webinar. So thank you again for attending, and thank you for all of your questions. Obviously, with over 100 questions, I'm not going to get to those in the next 8 minutes, but I can pull a few here. So let's consolidate a few themes here. Immediately, I can see a theme emerging concerning confusion about ban-the-box laws that require an individualized assessment or pre-adverse or adverse action notices that differ from the standard letters that you send out. Okay, as I mentioned earlier, you cannot adopt a one-size-fits-all approach to compliance. You're going to have to create separate processes to comply and unique letters for each candidate with a criminal history being considered for work in one of those jurisdictions. Think about this, right? If you're conducting a background check in California and you need to conduct an individualized assessment, every candidate with criminal history, their criminal history is going to be different, and the circumstances impacting their individualized assessment are going to be different. For example, have they worked in jobs that are similar to this? What is the period of time since that last offense? That is going to differ by candidate. So all of those notices and all of those letters are going to differ by candidate. As a result, this isn't something that a background check vendor, for example, HireRight, can do for you. We cannot conduct those individualized assessments on your behalf because a vendor can't know your organization's risk tolerance. But if you are a HireRight customer, we do have tools that you can use to help manage your compliance responsibilities. All right, there are a lot of questions about the geographic scope of ban-the-box laws. So do they apply to work location or residence? The super lawyerly answer, but the answer is it depends. Most ban-the-box laws generally apply to work location, but some requirements, such as New York's requirement to provide an Article 23A criminal history disclosure, that applies to all residents of the state. But take a look at at San Francisco's Fair Chance Ordinance requirement. So the Fair Chance Ordinance needs to be provided to any worker of the state. So again, there's differences based on geographic scope. That said, we do cover geographic scope in our Ban the Box white paper, which is available at the HireRight Resources Library. Download that white paper and you can take a look at how a Ban the Box law would apply to either work location or residence. I can say within Compliance Workbench, you can utilize both either element or both elements to help drive your compliance decisions. All right. Lot of questions about oral fluid screening and the laws in California and Washington. Clear theme about oral fluid screening used in compliance with laws in California and Washington. So in a nutshell, you cannot rely on traditional testing methods like urine or hair because they will not tell you if an individual is actively under the influence of marijuana. They just tell you that marijuana is in an individual's system. Oral fluid registers very recent use, and the laws and these laws in California and Washington, they permit an employer to adversely impact someone who is actively impaired or high. One other note I should raise about oral fluid screening, it can be self-administered, meaning your candidate can administer it against a certain protocol. I believe it's like we have, I believe, an app, for example, where a candidate can self-administer the test. This means that a candidate doesn't necessarily need to go into a collection site or into your office, which can be really beneficial as far as candidate experience is concerned. Although some collection sites, but not all, do support oral fluid screening. So if you do want somebody to go into a collection site, that is something that can be supported within some limited cases. But again, oral fluid is your friend if you want to continue to test for marijuana, for THC in either California or Washington. You need to have amended your drug testing panels as of the start of the year. If you have not done that already, please let us know in your survey and we can help you support those changes. A few folks have noted that I did not cover state privacy laws. You're right. There was a lot of action at the state level as far as privacy laws were concerned in 2023. Far too much for me to cover in this webinar, but the good news is that they do not impact background checks conducted in compliance with the Fair Credit Reporting Act. So again, a background check conducted by a vendor like HireRight in compliance with the Fair Credit Reporting Act is exempt from the scope of all state privacy laws. That said, if you conduct background checks in-house outside of the scope of the FCRA, or if you gather other employee data, for example, as part of your employment applications, they may be subject to a state privacy law. So you would want to be familiar with those particular requirements. For what it's worth, even though I did skip over the privacy section today, I did link to a privacy chart within the resources section of this webinar, so you can check that out. All right. A few more questions. Questions about the I-9 flexibility that ended at the end of the pandemic. Again, this was the virtual remote flexibility. So before USCIS permitted us to be able to conduct virtual remote examinations of list A or B and C documents during the they allowed us to do this during the pandemic, but they ended that practice this summer. They did require that all of those I-9s that were virtually inspected during the pandemic be re-verified. Some of the questions that I'm receiving are, do we need to rerun all of those I-9s that were verified by a remote means during the pandemic? The answer to that is absolutely not. Do not rerun an I-9. You should never rerun an I-9 in these cases. However, you should re-verify those original I-9s that were accepted using virtual remote means during the pandemic, and you should have done that by August. So again, if you do have further questions about that, let us know. I did write a blog about this. It is available at the HireRight blog. I didn't specifically link to that one here, though. So with that, we are just about out of time. You can expect this webinar to be posted to the HireRight resource library within the next few days. You'll also receive an email with your SHRM or HRCI credit information in a few days as well. With that, I'd like to thank you all for your time today. Again, please take 60 seconds to complete the webinar survey. I take your feedback really seriously, so let me know how I'm doing. It is my report card. There are several thousand of you on this call. I want to know how I am doing. With that, we will chat again in April, where we're going to talk about all the new legislation that's being debated by lawmakers. I'm tracking over 300 bills just to give you a sense of how busy things are right now. So we'll have a lot to talk about in April. Until then, thanks again for spending a portion of your day with me, and we'll meet again in the spring. Thanks, everyone.